SCOTUSblog editor Zach Shemtob on the Supreme Court's slew of recent gun decisions. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of thereload.com, where you can head over today and sign up for our free weekly newsletter if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news and analysis. This week, we are talking about the Supreme Court, which really, they laid down all of their gun cases in 1 week. So we got a lot to talk about. They unloaded all of their gun cases, so to speak. Yeah. Yes, to do that, we have with us a special guest from SCOTUSblog, the new executive editor, Zach Shemtob, with us. Welcome to the show, Zach. Thank you so much for joining us.
It's great to be here. And by the way, I really respect the Reload and what it's trying to do by lending, sometimes too rare, sober, independent analysis to Second Amendment and gun issues in general.
Thank you. I really appreciate that. It's exactly what we are trying to stick to doing here at the Reload. It's what I think sets us apart a little bit from a lot of other publications out there. But speaking of which, SCOTUSblog is, I think, set apart from a lot of other publications out there for similar reasons. One that I've followed for years. It's kind of become the go-to place anytime, Thursday rolls around or there's an order list that comes out or whatever. You go sit at the live blog that with experts who there at the court and get a really good understanding of what's actually happening on the court. So speaking of which, could you just tell us a little bit more about yourself and SCOTUSblog before we get started?
I am executive editor of SCOTUSblog as of 2.5 weeks ago. So I have just started in this position. Before that, I was a practicing lawyer, actually, criminal defense. I dealt with mostly white collar, alleged crimes and things of that nature. Before that, I was actually in academia and I got my PhD in criminology. So the criminal law world is one I'm very familiar with and one, that I will bring a little more of to SCOTUSblog in terms of that background. But I'm extremely excited to be at SCOTUSblog, and especially during this time where the Supreme Court, for better or worse, has taken on so much importance.
Yeah, absolutely. And SCOTUSblog was recently acquired by the Dispatch.
Yes.
Right, which is another publication that I love and that I'm a contributing writer for. But also seems like you guys are investing into SCOTUSblog as well. Amy Howe, who's been the longtime leader of the publication, is still there, still editor, right?
Yep.
So nothing is changing in that regard. But you guys seem to be, kind of trying to expand things as well.
Yeah, the goal is to have a lot more outside contributors, and the Dispatch is giving us the resources to do that, which is wonderful. And also next term to cover every case rather than just the most quote unquote important cases, and to, expand our coverage just in general. And the Dispatch is, as I said, giving us the resources. And we are, also remaining as independent and nonpartisan as possible, which Amy does so well and will continue to do it in that vein. And so we've got to know, the Dispatch has also been wonderful and very clear that they want SCOTUSblog to remain SCOTUSblog.
Right. Because, it is a very valued institution. So people are going to be watching closely how you guys run things there for sure.
We don't want to lose that credibility.
Yeah, absolutely. And that's what really matters in this business, right? Is your credibility, your reputation. So I'm glad to see that you guys are still focused on that. And everything I've seen so far, I've been very happy with, and I don't notice any, shift in how you guys are covering topics, certainly. So that's good. But speaking of which, let's get into our, the specific area of the Supreme Court jurisprudence that we are interested here at the Reload, which is their Second Amendment. And I guess not all Second Amendment, right? Just gun-related topics. Because, for instance, the first one I think we can get to is their unanimous holding, maybe that might have surprised some people that it was unanimous, in Mexico v. Smith and Wesson. This is a case about Mexico trying to hold Smith and Wesson and other American gun companies liable for $10 billion worth of damages drawn from cartel violence in Mexico that's carried out with American-made firearms, right? What was the holding there?
So
the background?
The court unanimously ruled that the Mexican government couldn't bring a suit against American weapons manufacturers for aiding and abetting gun violence in that country. And, you know this, but by way of background, Congress passed a federal law in 2005 to shield the gun industry from lawsuits in U.S. courts that were dealing with, others using weapons, using guns. It passed in the Senate 65-31. So actually a lot of Democrats joined. Biden and Obama were not among them. And that's known as the Protection of Lawful Commerce in Arms Act, or the PLCAA.
And this is the first case that dealt with that.
I believe that's right.
Law, right?
Yeah. Yes, I believe that's right. And so in 2021, the Mexican government filed a lawsuit in a Massachusetts federal court against 7, major U.S. gun makers. And this is all, by the way, covered on SCOTUSblog. So I'm just re-going over that. But and a one gun wholesaler. And the allegations from the Mexican government were that gun makers such as Smith and Wesson, Glock, Colt, etc., had designed and marketed their guns as military style weapons, especially the AR-15, and knowing that doing so made them more attractive to drug cartels in Mexico.
Right,
and
that's
so
the allegation.
The allegation was essentially that these gun manufacturers are aiding and abetting gun violence committed mostly by the cartels in Mexico.
And they also argued that gun makers could impose more restrictive means on gun sales by, further down the chain dealers if they really wanted to, and that not doing that assists as well in this trafficking that occurs, the illegal trafficking that occurs.
Correct. They called it a 3-tier distribution system, facilitating an illegal market for guns in Mexico. So gun makers will sell to wholesale distributors, and then wholesale distributors will sell to retail dealers. And then those gun dealers will sell to others. In this case, the Mexican government alleged they were selling to straw purchasers, buyers who were acting as fronts for someone else who couldn't legally own a handgun. So the Mexican government alleged that they were part of this whole system and knowingly engaging in these activities.
Right. But they didn't have any specific evidence of certainly the idea that they really didn't present any evidence that specific to somebody actually breaking the law here. They're kind of talking about guns get trafficked to Mexico every year. A lot of guns get trafficked there. And the gun companies know that's going to happen, and they don't do the certain things we want them to do, like stop making AR-15s or some of these guns with Spanish names, or impose more restrictive sales policies for their dealers for American gun dealers down the line. That go beyond what American law requires. That's sort of because the gun companies aren't doing this, and they know that some of the guns they make are going to end up in Mexico. Correct. They should be liable for the violence that occurs.
And the Mexican government's complaint wasn't a model of clarity, I will say, but ultimately it seemed to boil down to that the gun manufacturers were aiding and abetting these crimes. In its unanimous opinion, written by Justice Kagan, I may add. So I just want to take a side note. We had 3 very important opinions yesterday, 6 in all, but 3 in particular were particularly impactful. Of those 3, they were all unanimous and all written by a different liberal. And so this case, which in some senses was among the most controversial, the reverse discrimination case, Ames, was also quite controversial in some, to some. But anyway, this one was written by Kagan. And so Kagan explained that to hold someone liable for aiding and abetting a crime, the person or entity has to take an affirmative act to advance the offense and intend to facilitate the commission of the crime. And I think the key for Kagan, the key passage, is she wrote that the Mexican government had only alleged indifference by the gun makers as opposed to assistance. So since they hadn't provided assistance to the cartels or to this 3-tier system, as opposed to just being indifferent to it, they couldn't be held liable for aiding and abetting, and therefore they couldn't get past the statute.
Yeah, and so their suit is not allowed under the Protection of Lawful Commerce in Arms Act, was the conclusion of the unanimous court, which I think some people were surprised to see a unanimous court in a gun case like this. Although I will say, not the first time they've been unanimous, right?
It's true.
The Vulu with the NRA, and also neither one of these is a Second Amendment case technically.
Yeah,
they're this is a PLCAA case.
Yeah,
right. There's sort of Second Amendment implications.
Yes,
the NRA case was a First Amendment case, but you saw a unanimous ruling in a gun case, and a lot of people, lay people watching the court would not see that coming. There's a reputation for being a 6-3, 5-4 court. But that's not really that true. And I, if you watch the oral arguments in this case, I predicted at the time it was probably going to be pretty lopsided. And so I wasn't surprised to see that it came out this way.
It was very clear from the oral arguments. And Kagan writing it, everything she does is deliberate and intentional. I would say she's the most, they're all very careful, but she's the most careful, next to Roberts probably. And so every line, every word Kagan writes, she is thinking about, and she has given a great deal of thought. So there's nothing here that was sloppy. This was entirely intended. Could it be part of a larger strategy to kind of find common ground with the conservative court? Yes, absolutely. And I think that's why you saw in all 3 cases a different liberal kind of writing unanimously. Yeah. But in any event, what was written here, every word Kagan meant.
Yeah, I mean, I saw, was it the Waldorf, Chris Geithner's independent publication that follows the court as well, was noting similarly that, there may be some strategic thought behind what the liberals are doing in some of these cases. Like they're trying to find ways to be unified with the rest of the court. It seems and probably I would imagine Roberts is also the whole court is trying to find common ground on some of these bigger cases, it seems like.
I'm sure that out of everyone on the court, Roberts was the happiest. Yeah. Because there's nothing he likes more than unanimous opinions, which he sees as lending credibility to the institution.
Mm-hmm. Well, yeah, and not for no reason, right? That is something that absolutely people look at a 9-0 Supreme Court ruling, and I think they do feel like whatever the outcome was, that it was the right, that it has
absolutely was
cross-partisan credibility.
Now, the lower court, the First Circuit, had found differently. So it was actually a reversal of the lower court. I will say, though, that the First Circuit is 5-0 Democrat appointees. I think at this point, one can safely say it's the most liberal of all the circuits. Folks used to always point to the Ninth Circuit. That is no longer the case. The Ninth Circuit is actually quite balanced in many ways these days and has some fascinating opinions. But yeah, the First Circuit, if you're going to go predict a liberal outcome, that's your top choice.
Interesting. Yeah, and they had ruled that the key finding here was foreseeability, that because these guns will get trafficked through this system, and that it's foreseeable that will happen because it's happened in the past, that the lawsuit could go forward. That was basically the lower court.
The Supreme Court wasn't having it.
No, not at all. None of them, right?
Not even Jackson or Sotomayor.
Yeah, Jackson. So there were 2 concurrences here, right? There was Thomas and there was Jackson. And Thomas, unsurprisingly, perhaps, wanted the court to go further than what it did. The court just basically said Mexico's case is pretty bad. They don't even claim, specific crimes. They don't point to specific gun dealers who are these bad apple dealers that they're talking about. They just sort of generically describe the system as being, on the whole, the problem, and they don't point to anyone in particular that the gun companies have supposedly aided and abetted here.
Correct.
And that was a big problem for the majority in this case. And Thomas wanted further than that. He wanted to say, in order to get past PLCAA's liability shield, you not only have to have like a plausible argument that somebody has committed a crime, you actually have to have them be convicted of a crime first.
Right. Well, he says there is an earlier finding of guilt or liability and an adjudication regarding the violation.
Right.
So there needed to be some finding of guilt or liability, in his view, for you to get past the PLCAA.
Yeah. And nobody joined that one.
No one joined that one, not even Alito or Gorsuch.
Yeah, and which is something I want to get into later on in the show, just where Thomas is with the court on Second Amendment stuff, and because I want to get into some of that juicy like speculation, educated guessing on what some of these things they're doing.
It's going to be a long interview then.
But we also had Jackson give a concurrence here, and hers was I don't know. When my reading, I was like. It's fairly redundant. Like it kind of just reemphasizes the same thing the court has said when I read it. I don't know. What did you think of it?
So I think Jackson was the most liberal in this regard. I think she was saying that a potential claim could be successful if brought by the Mexican government or another entity, but that had just not been met here, that this aiding and abetting was not going to cut it. But she's not ruling out that other claims in the future. She didn't say this directly, but this is what I get from her concurrence, that other claims in the future might do the job, might satisfy the ability to get past the statute.
Yeah, but I feel like that's what the majority was saying too. Right?
Yes and no. I mean, I feel like Jackson really put a point on that and wanted to, sometimes concurrences are used to emphasize something that was already in the majority opinion and say, well, pay attention to this point.
Certainly. I don't know. It just because even on that front, it still felt like a lot of times you'll see courts, if they rule against someone that they really want to win a case, they'll just lay out like, here's how you could actually do this case and have it work. And I don't know that, do you feel like that's what she's trying to do there? It didn't feel like there's specifics of how Mexico could refile this case to make
she
it work.
Either didn't know or wasn't ready to make that suggestion and to, lay that out. So I think that's correct. I think she's just keeping it open that there may be some possibility out there that a successful claim could be brought, but this certainly wasn't it.
Okay. And whereas Thomas is saying, you really shouldn't be able to do any of these.
It would be if you had a finding of, guilt or liability, an adjudication, sure. But again, that's going to involve a whole separate process.
Yeah. Yeah. And there's some more lines in the Mexico case I want to get into later in this discussion, because I think it comes back around. As you mentioned, you said Kagan writes these opinions very specifically. And there's a couple lines in there that may inform our next discussion here, which goes back to Monday when the court issued its order list and finally made a decision on what to do with two major gun cases, hardware ban cases. One being Ocean State Tactical v. Rhode Island, which deals with Rhode Island's magazine ban and confiscation law. But it was at a preliminary injunction stage, which, by the way, the court has been extremely reluctant to take up any Second Amendment cases at anything but the final merits stage.
Which, in my view, is the way it should be for all cases. Okay. They should really, except in very serious circumstances, they should wait for the merits, everything to have been hashed out, because they're the final decision makers, and so they should have everything before them.
Okay, but they don't do that for all cases.
No, they do not.
I mean, they have a whole emergency the shadow doc. Right?
We can. This will be a truly long podcast.
We don't need to get into
maybe in a future one, I'm happy to discuss the emergency docket or shadow docket or interim relief docket, short order docket. Everyone has a different name for it, but yes, that has become much more prevalent.
But so I guess what they're doing in these Second Amendment cases, not taking them at earlier stages in litigation, that's maybe what the ideal is for these justices, but not what they always do, right?
Yeah. I mean, a lot of the shadow docket cases are also admin law cases, personnel cases of the administration, now the Trump administration, making these, large moves, whether in restructuring the federal government or at least, federal agencies. And so the idea is there in order to prevent or to enable Trump to restructure it after that's been stayed by lower courts. They need to get to the Supreme Court immediately or it'll be too late. I mean, same thing in terms of deportations.
But people obviously would make that same argument about, this Rhode Island case is a good example. Like, this is a law where not only do they ban the new sales of these magazines, but they ban possession of them after a certain point. So
correct. You got, what is it, 6 months? Or what was the time period in which you had to essentially restructure the magazine or sell it off? It was, Right. So, and that's why there was also, interestingly, and it was brought by Paul Clement, one of the great Supreme Court advocates, an argument that there was a takings problem here, violating the Fifth Amendment, the idea that the government can't take your property without just compensation, and that they were also violating the Fifth Amendment by putting this law into effect.
But I guess they just don't, I don't know, for whatever reason, they don't view that as quite the same as some of these administrative law cases that they do.
No, they don't. In administrative law and immigration cases, I think because there's a long history of allowing Second Amendment cases to percolate and to go through the system.
That is definitely one way of putting it, yes.
Yeah. So traditionally, they have treated these differently than many others.
Well, that's Thomas's complaint, right? That they treat it like a second-class right.
You beat me to it. Yeah. I mean, I'm not going to take a position either way. Thomas is certainly the advocates of gun advocates. Maybe that's putting too strongly, but believes in the Second Amendment and that it protects that individual rights. Have again and again made clear that this is being treated as a second class right. And for some circuit courts, they may well have a point.
Yeah. And so, it's interesting because the Ocean State case, the magazine case, does mirror the bump stock case, the Cargill case, because that was another one where there was no way to legally keep those bump stocks under that rule from the ATF during the first Trump administration. And that came up to the court in a similar manner of like, please block this before the deadline goes into effect. And they declined to do that. And then later on, when they did take up the case, they still they found the rule to be unconstitutional, not under Second Amendment grounds, but still it's just kind of I don't know, certainly a quirk of the system, maybe put it lightly, to say that they thought the rule was unconstitutional in the end, but they let the confiscation aspect of it happen. I don't know. Either way, I guess this is the reason why it's not surprising to see them not take up Ocean State Tactical, because it was at this preliminary injunction stage. Although there were 3 dissents, and that 3 would have voted.
Like in Snope, I mean, these cases have been relisted 14 times. They were considered at 15 separate conferences. And by the way, just for those who aren't, as attuned to it, relist means the court considers it at a conference and then kicks it to the next conference. By
the way, how does that, what do we know about how that actually works in practice? There's a lot about the court that's behind the scenes. We don't see it. What do the conferences look like? Why do they need 15 times to talk about these cases?
It's impossible to know why something was relisted. The court never lays out its reasons for that. It could be a number of things. It could be, one, you have 3 justices who are ready to grant cert, and there's a 4th who's on the fence, and so keeps pushing it forward and saying, okay, next time, let's think about it. There's also the possibility that the court has already decided to deny cert and a bunch of dissents are being written. So that can take up some time.
So with that in mind, the next case, the one that was at final merits, that's another like marquee case for the gun rights movement, certainly, and in the fight over Second Amendment rights generally, was Snope v. Brown, which is the Maryland assault weapon ban case that Maryland's assault weapons ban, which targets firearms like the AR-15 and similar guns for a ban on sales. It's not there's no confiscation aspect to it like the magazine case in Rhode Island, but this is the main policy everybody's been fighting over in America for 30 years, basically, and it's one the court has not ever ruled on. And here we finally got to the point. They had one come up from Illinois earlier on the preliminary injunction basis. They denied that one. Now they have, and Thomas wrote a statement in that one and said something to the effect of, I understand that the court, is waiting for a final merits case to take this. And that's, okay. But now we have a final merits case. They relisted it 15 times, and we got the conclusion on Monday, which is that they are not taking up that case, that there were 3 votes to take it up. And then perhaps most instructive of it all, we got a statement from Justice Brett Kavanaugh that was not a dissent, but an explanation of the denial. And so I guess it wasn't very long. Neither was the dissent. So it certainly didn't take 15 weeks for either one of those to be written, I would imagine. What do you think happened there?
It shows that there was some internal debate, and at least someone wanted to keep kicking it each time, and they just couldn't decide on it. It is rare to see a relist, 14 relists, 15 conferences. It's not unheard of. Dobbs, I think, had 12 relists or something like that.
Right.
And there are some death penalty cases that have actually had over 20.
Really?
So it's not entirely unheard of, but it is very rare. And yes, but to go back to Kavanaugh, Justice Kavanaugh agreed with Roberts, Barrett, and the 3 liberals to deny cert. And then he wrote a very interesting respective denial for cert, where he made some of his thinking quite clear.
Yeah. And look, Kavanaugh has ruled on this question before. When he was on the DC circuit, he was in the minority in a panel that decided Heller 2, which is the follow-up to the famous landmark case about DC's handgun ban. The same guy, Dick Heller, filed another lawsuit against DC's assault weapons ban, or ban on AR-15s and other, the sale of those firearms. And the panel upheld the law, but Kavanaugh dissented and said, essentially, these are in common use. It's basically the same case as the handgun case. You can't ban the most popular rifle in America, right? Yeah. And which is something that you've seen Thomas say in these dissents
again and
as
again.
Well, over several times now over the years. But and it's what Kavanaugh repeats here in this statement on the denial of Snope. He basically just says straight up, the Fourth Circuit was wrong to uphold this law, and that these guns are almost certainly protected by the Second Amendment, which is interesting to say when you're denying cert in the case.
Yeah, I mean, just to kind of summarize it, he made clear that in Heller, the court further, held that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense. In fact, the AR-15 is the most commonly bought rifle in the United States. I think approximately 16 million Americans own AR-15, or that was the number that they gave at least. I'm not sure how accurate that actually is. Right. But he said, despite that, he wasn't ready to hear the case. And he gave the reason for that as, and I'll actually read it off, opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for cert will likely be before this court shortly. And in my view, this court should and presumably will address the AR-15 issue soon in the next term or two. Now, there's 2 very weird aspects of that paragraph.
Yeah.
The first is what new information, given that Kavanaugh just said, that he understands it in this way, what new information could the courts of appeals provide to him that would make a difference here? And
that was Thomas's point in his dissent.
Absolutely.
He was like, we're not going to learn anything new from percolation. He says it's been 10 years. We know everything we're going to know. I mean, now you could, obviously Bruin has kind of changed the game and as far as interpreting modern firearms restrictions go. But I would even say it's a bit of a stretch to say percolation is going to have any effect, because the lower courts have really solidified around the logic to upholding some of these bans or striking them down. And I don't know that there's going to be any innovation in these cases coming forward. But interesting thing to say.
And then the other interesting thing was this presumably will address it in the next term or 2. Actually putting it out there that, we're going to make it happen soon. It's right. He's very confident. He's talking to Barrett and Roberts, and he's basically saying, this is going to happen. This is how I'm going to vote. I hope you'll join me. Nudge, nudge, hint, hint. Let's see how it goes. That's
interesting, because there's a couple ways to look at it, right? I think There's the one where he's trying to talk to the other two conservatives that are maybe on the fence and nobody knows how they're going to vote. Because if everybody knew that Roberts and Barrett were going to vote to uphold Snope, the Maryland assault weapons ban, then presumably you could get 4 votes to take the case. And if everybody knew they were going to vote to strike it down, you could get 4 votes to take the case. So the fact that they didn't get 4 votes one way or the other on this is maybe a sign that people aren't sure what Barrett and Roberts are going to do. I guess it's hard, but Barrett and Roberts, to be like, they've been on the side of all the majority of conservative justices in all of these Second Amendment cases. Roberts was on Heller, right?
Absolutely. And Barrett is written on the issue in Cantor versus Barr. Right. She had a very influential opinion, dissent, excuse me. And so, but Roberts is an institutionalist. He clearly cannot stand, all these hot button issues coming up at once. Yeah. So he generally tries to avoid too much culture war stuff. He doesn't always get it right. That's what I was wondering. Yeah.
That was the other thing I wondered is like, well, is Kavanaugh speaking for Roberts and Barrett, or is he speaking to them, as you said? When because he's not saying, he doesn't say they should take, he does say they should take it up, but he says they should and will take it up.
Yes.
Meaning like he knows that they're going to do it in the next, and he gives a timeline. He says that the next term or 2.
Yeah.
And so it kind of feels like this court is famously, it famously doesn't take a lot of cases.
Yeah.
Right. It's much slower paced than previous courts have been.
60 to 80. Yeah.
Maybe they just didn't and he talks about how, look, there's a lot of opportunities to do this case. He's clearly got a foregone conclusion about how he's going to rule, but he's like, this is not the last time we're going to have the opportunity to do this.
Correct.
We can wait a year or 2. We'll come to the same conclusion. Thomas obviously doesn't like that idea. He directly says that's, disrespectful to all the people who are, living under a ban that we are going to rule unconstitutional, right? Is sort of the implication, or a ban that he says is unconstitutional. Yeah. But I don't know. Interesting thing. I definitely got the feeling that Kavanaugh is very confident that they're going to take a case, right? Which makes you think he's confident that his view is going to win out.
He's making it very clear, and I think especially to Roberts and Barrett, Roberts being the institutionalist and Barrett's a proceduralist. One thing we've learned, she is a proceduralist. So she believes very much in proper procedures being adhered to in a particular way. So that may partly explain why she didn't join here. But I do think that, yes, these cases, as Kavanaugh puts out there, will be taken up soon, finally. And at that point, I do think at least Barrett or Roberts will join the other conservatives.
Yeah. Yeah. I mean, they only need one, right?
Correct.
That seems pretty obvious, pretty straightforward.
They're not, even though there was some interesting language in the Mexican case, you're not going to get Kagan, you're not going to get Sotomayor, and you're not going to get Jackson.
Well, let's talk about that real quick, because that is the other interesting thing from this week's rulings, is that, as you mentioned, Kagan is very particular in what she puts in her opinions. And this Mexico case was a unanimous decision. Nobody was dissenting from any part of it. And no one, other than what we already discussed with Jackson and Thomas and some of their views on in their concurrence, no one takes issue with any of with what is a very particular phrase. I'll just read it directly because it is interesting. As noted above, Mexico here focuses on the manufacturer's production of, quote, military-style assault weapons, among which it includes AR-15 rifles, AK-47 rifles, and 50 caliber sniper rifles. But those products are both widely legal and bought by many ordinary consumers, parentheses, the AR-15 is the most popular rifle in the country. The manufacturers cannot be charged with assisting in criminal acts just because Mexican cartel members like those guns too. So, I don't know, the majority saying, written by Kagan, saying the AR-15 is the most popular rifle in the country, just straight up claiming that as fact. I mean, they cite a NPR story, and I think it's not really in dispute that that's the case. But interesting thing, I mean, is not, those products are both widely legal and bought by many ordinary consumers. Isn't that common use? right?
Yeah, it's surprising. I mean, when the ultimately the test here that seems to have been developed through Heller is, the government can ban dangerous and unusual weapons.
Right. But
And
they have to be both.
The famous, the and there is key. It reminds me kind of cruel and unusual punishment under the Eighth Amendment. So it's an area of mine is the Eighth Amendment. And courts have kind of read out the and made it into more of an or. And so we'll see if they do that here. And I think some
lower courts have. Yeah.
Exactly. Some of the lower courts have. But you have this, whether they're a dangerous and unusual weapon. And the idea is if they're in common use, no, they're not an unusual weapon. But then you have this other line in Heller, which is weapons that are most useful in military service, M16 rifles and the like may be banned. And so a lot of the lower courts have used just that language to carve out AR-15s from being, recognized as guaranteed by the Second Amendment.
Right. And that even happened in Snope. That was one of the linchpins for the Fourth Circuit, was this idea that AR-15s are military style weapons, and dicta in Heller has that line.
By the way, for what it's worth, the Fourth Circuit's opinion was written by J. Harvey Wilkinson, who's actually a judicial conservative appointed by Reagan. And he pivots a little on guns, but it was interesting to see that unlike the First Circuit, which is a very liberal circuit, here you had an opinion written by traditionally a more conservative jurist.
Yeah, but so I guess what it seems like you don't think we should make too much of this line showing up in that Mexico opinion, even though it was written by Kagan. And I think, I think most people would assume that the three liberal justices are not going to vote to strike down an assault weapons ban. But I don't know. There's been some arguments, as we mentioned earlier, this idea that maybe the liberals are trying to get on some of the borderline stuff. Maybe they're trying to show that unified front so they can perhaps strategically get conservatives to come to their side on things down the line, or I don't know, or something.
To get conservatives in cases like those here. So I think that these three cases were all interesting. They were all, to a certain extent, hot button issues. But I think it's to eventually say, well, we voted that way, and on the AR-15 issue, come on, will you join to the more conservatives? Will you join us since we were reasonable on these other cases? But I think this is such a hot button issue that it's one that for better or worse, and I'm again not taking a side here, but I do think that reading tea leaves, I find it highly unlikely that Kagan, Jackson, Sotomayor will end up voting with the conservatives on this one.
Well, we have seen them do this in the past. Well, not this exact court. It was 2016. Saitano dealt with. Now that was not it was not as controversial of an issue because it was stun guns, right, which are non-lethal or less lethal weapons. But you had a per curiam ruling that said, they're protected. I mean, it just reinforced the idea that modern weapons are protected. It's not just the weapons that existed at the founding era, which the court, I think, Alito had a concurrence that called it, nearly frivolous argument from the Massachusetts Supreme Court at the time. But, I don't know. I'm just saying, I would be very surprised, like you said, I'd be very surprised if you got any of the liberals on board with striking down a ban on AR-15s. But I'm surprised to see a unanimous opinion written by Kagan where she includes the line that AR-15s are popular and then essentially owned by ordinary citizens, by many ordinary citizens.
No, I agree. And as I said earlier, everything Kagan writes, she's an extraordinary writer and really deliberate jurist. Everything she writes is intentional. So, you can't just write it off, even though, again, I think it's unlikely that Jackson, Sotomayor, or Kagan would join, the others in terms of saying AR-15s are protected by the possession protected by the Second Amendment. Yeah.
So it probably comes down more to what do Roberts and Barrett think? And while Roberts and Barrett again have been on the majority side, or at least the with the majority of conservatives in all of the Second Amendment cases. Neither of them have explicitly written on assault weapons bans in the past. The Cantor case that you mentioned for Barrett was about nonviolent felons, which
Correct.
did take a pretty expansive,
I think it was mail fraud. I think.
It was mail fraud. A guy convicted of mail fraud, and she said that that's where she gets into like the dangerousness idea, the standard that they talk about in Rahimi that they've yet to revisit. But she was in the dissent on that. The more pro gun position of the ones available in that case she took. So, and again, she's been on the same side as the majority of conservatives in all the gun cases, including obviously Bruen, being the most important one. But and I guess just real quick to put a cap on this, we're talking about the different justices and where they're at. And I think it's hard to know exactly where Roberts and Barrett stand, other than that they didn't vote to take up this case, while the other four seemed like they would have. But again, their history, it doesn't indicate any real big split between them and the other conservatives on Second Amendment stuff, except for Thomas, who seems to be split he's certainly more aggressive on the issue than the other conservatives, it appears, based on just a couple of things. And this is where I want to get your input of what do you think's going on here and whether he's isolated on the issue or not. Obviously he wrote Bruen, which is the Second Amendment test that
which
now
was joined by Roberts, by the way.
Right. So all the conservatives joined that. But then the very next case, Second Amendment case they took, with the first time they applied that test, it's 8-1 with Thomas in the only dissent in that case. And then now you've seen him do a couple of dissents to these cert denials, the Illinois case, this case, Snope, in Maryland, where no one's joined him in those statements either. Now, not that they don't have a similar point of view, but I don't know. I'm just wondering if you think he's becoming isolated on this, or what should we make of it? Am I reading too much into it?
I think Thomas is doing what Thomas has always done. He's staking out his claim. He's making clear this is my position, and he thinks down the line he may have more sympathetic justices join him. This has been his way now for many years. He wrote many dissents, which at the time were scoffed at, sometimes joined by Scalia, and just seen as, this is way too radical. And as time has gone by and things have changed, he's been, for better or worse, he's been vindicated. So I think this is part of Thomas's MO. He's, as I said, he's staking his claim and he's saying, if no one joins me, so be it, but people will join me down the line.
Interesting.
And the interesting one to see is if Alito or Gorsuch joins him. And, Gorsuch on some things is super aggressive, like can be really, all in. On others, less so. This is one where he seems to, Vanderstock's such an interesting case because it's a conflict, I think, between
the ghost gun case,
Gorsuch's textualism and his libertarian leanings. And the textualism, I think, in his view, won out there.
For Gorsuch.
Yeah.
Because I will say, like, that Vanderstock is another one where Thomas was in a small minority, and that time he was joined by Alito.
Yes.
And actually, I was kind of wondering if you read his denial, his dissent to denial in Snope, the last paragraph of it talks about Vanderstock, and his complaint is that he thinks the way the court upheld the ATF's so-called ghost gun rule, or the frames and receivers rule, implicates this big problem where ATF, if it wanted to, could just ban all AR-15s as sort of precursors to machine guns under the logic the court used. That's what Thomas argues in the very last paragraph. Most of his dissent is just about the idea that AR-15s are in common use and protected by the Second Amendment, and there's no need to wait for more percolation. It's been 10 years. We're dragging our feet. We wouldn't do this with other constitutional rights, he claims, right? Typical stuff that you'll hear from Thomas on this issue. And then in the last paragraph, he's like, by the way, Vanderstock was terrible.
Yeah,
and,
that may have,
I wonder if that's why people didn't want to sign on.
that may have alienated Gorsuch.
Yeah.
But again, Thomas is not afraid of alienating folks because he thinks in the, at the end of the day, he will be vindicated and proven right. And there is, again, for better or worse, there is some history of that.
Yeah, absolutely. All right. Well, I appreciate you taking the time to join us here and give us your insight into what the court may be thinking on these things. I don't think there's a better publication for that than the SCOTUSblog. So I'm glad that you joined us today, and hopefully we'll have you back on in the future once they load up on some more gun cases. I guess we're done talking about them. There's some that are seeking cert, but nothing. They've cleared their plate.
For this term, I think we're finished. But yeah, it was an absolute pleasure to be here, and I look forward to future conversations. Absolutely.
And so, and if people want to follow the SCOTUSblog and they want to see the coverage that you guys are going to do on the Supreme Court, and especially as it relates to this Second Amendment and gun issues, where can they do that?
Yeah, you can, just go to SCOTUSblog.com, and we have all sorts. You can go to the case term and see all the cases that are pending. You can check out our statistics and see those. For instance, if you click on the case page for Snope or the case page, I think for Heller back in the day, it'll bring you to all our writings on that. You'll get, you get the Supreme Court docket. It gives you all the information you need on these cases.
It's a great resource, truly is. So I encourage people to head over to SCOTUSblog and check it out today if they haven't already. Appreciate you coming on. We'll have to have you on in the future as well. There will be, I'm sure, a lot more cases to discuss. So I'm looking forward to it.
Kavanaugh's, putting it out there. So 1 or 2 terms, we'll be back again.
Kavanaugh's already given us a deadline, a couple years, which cold, I think, like I said, I think it gives, to me, the insight is they're probably going to strike down this law at some point in the future. That's cold comfort to some degree for gun rights advocates, I think, who you're basically telling them, oh, don't worry, a couple of years from now, you'll get what you want. And it's been, Heller was 2008. McDonald was 2010.
Yep.
That was Thomas's point in his dissent. So, but I think it's still anything you can get where the Supreme Court's giving you insight into what they're thinking is valuable. All right, that's all we've got for this week. We will see you guys again real soon.